what I did before. I'll probably just continue to keep pitching frameworks, my projects, to see if something can land. Maybe they'll like me as a writer, and then I can get in that way, or do a script review with one of the guys there once I start making money, and see if I can get my script in his hands. That's the only way that I know, other than maybe trying to get a manager.
Right. Well, first, let me ask you that. You submitted it yourself, or this was our submission? Did we submit on your behalf?
No, I submitted a personal letter like 2 or 3 weeks ago.
All right.
I just want to leave Hamblin.
Yeah. Yeah, it's likely that you're not going to get a response because it was sent by you personally. Okay. You'd have a better chance of getting a response if it was sent through a third-party manager or entertainment attorney, because it's protected from arguments of copyright infringement. Because when it's sent through a third party, it serves as a witness, basically, a declarant, saying that this work was being submitted to this recipient on this date, that it was in fact this person's work. The studios and producers get very hesitant over unsolicited work because of the fear of a copyright infringement lawsuit. They're introduced to a lot of creative ideas, a lot. So they need to have a barrier in between them for legal protections. Otherwise, everyone would be saying that they took their idea. And a lot of times there's innocent infringements because they're just presented so many ideas. And you'll see there'll be some works that have a combination of your elements, maybe with some other works elements. And that's how these producers and studios get away with infringement. They'll say that they're not using your work. They're not going to accept your work. It's unsolicited, but they may have in fact read it. Believe me, they briefly look over things. They're looking for inspiration as well. But what they may do is take elements from one work that inspire them and then combine it with some other elements of another work, and then they can escape liability for infringement by saying it's a different work, or it's something they had independently in creation prior to the time of receiving your work. That's a tough situation when they start to combine those elements. So they kind of get away with the theft. Does that make sense to you?
Yeah.
Yeah, I mean, they're presented so many works that it's really hard for them not to infringe on the copyright. They just have so many, they're just overwhelmed with the opportunities to take it, and they'll combine it with other elements. What I believe should be done right now, since you received the letter, did they return your letter unopened?
Yeah, they did. Yeah.
Does it look like it was opened?
Doesn't look like it was open. But the script is out there, and I did pitch it to a DreamWorks guy. He gave me feedback on it that he's going to pass on it, didn't request the script. But
what you should do now, and it's a balancing act.
Okay.
Because on one hand, I will say this, that now you have created a open door line of communication and dialogue, even though they may not have accepted your script. But for future works, you may have a doorway to submit. Okay? Does that make sense?
Okay.
So keep track of all your records and your contacts. Your contact information is a valuable asset. Okay, so collect all those contacts. It's really a trade. That's considered a trade secret in your line of work. But what I will also say is that you should document now. And I call it a balancing act because you want to balance that relationship, that line of communication that you may submit future works to, versus how significantly do you want to protect this other piece of work. Every time you make a submission, you run the risk of your work being used without your compensation, without your permission, right? By, in my opinion, primarily the way of them just being presented with the work and so many other pieces of work, and they combine the elements. I think they're getting away with infringement in that regard, right? So you run that risk. But now you have to document after the fact that you need them to confirm they have no independently created work that is substantially similar to yours in any regard. Okay? Those are the elements for copyright infringement. Copyright infringement requires two elements: access to the work and an opportunity to convert it. And the second element, substantial similarity in the two works. And substantial similarity has been interpreted by the courts. So there may be different rulings in different jurisdictions.
Yeah, I mean, even if you pitch it and they take it.
I mean, what can you do? You're at a loss. You run that risk. That is the nature of the industry.
But is there a Wilder versus somebody that when you pitch it, you're protected under California law?
Right. You're correct. That's the case that we get the blurt out man doctrine.
Okay.
Have I ever spoke to you about the blurt out man doctrine?
No. What is that?
Okay. The blurt out man doctrine is based on the premise that ideas are as free as the air. We cannot put a monopoly on ideas. We cannot offer legal protection on ideas. But the law does protect those ideas that are expressed in a tangible medium, okay? It rewards the person who captures those ideas and puts them out into reality in a tangible medium. And tangible medium nowadays can be a hologram, it can be movements, choreography. It has expanded. Tangible medium is quite broad, all right, but it has to be captured. And then you're afforded federal copyright protection, okay? If you register your copyright with the Library of Congress. But ideas are as free as the air. So hypothetically, for example, you're in a cafe and you're having a discussion with, maybe it's someone in the industry. We'll pretend it's someone in the industry. So you're in a cafe, you're having a discussion, you're telling them about your new piece of work. You're speaking loudly, or maybe not soft enough so that the table next to you can't hear you. And so the person at the table next to you hears your idea and goes off with it and actually creates it, is inspired by your idea. There is no legal recourse for that. Ideas are as free as the air. Excuse me. Ideas are as free as the air. So you have to take your own protection. What is the best way to protect your work? Every writer asks me. the best way to protect your work is to never share it with anyone and lock it in your desk. Never share it with anyone. That's the only way you can truly protect your work. But that's not why you create. You create to share so people can enjoy, be entertained, be informed, or be inspired by your work. So you can't just lock it up in your desk, okay? However, California, certain jurisdictions have created a body of law. New York and California, based on court precedent, where it's based on contract law, implied, in fact, contract. They've created a new area of law based on court opinions, court decisions, implied contract law. What that says, or what that means, is that if there is elements of a business setting, you're not at a cafe, you're in an office, you're in a scheduled meeting, you guys have written confidentiality, NDA agreement, business settings. All right, you scheduled it through their, you're operating through a company, okay, private setting. If there are the elements of a business setting, the courts will imply a contract that if they were to use your work, you would be receive reasonable compensation. Okay, that's based on contract law. What is reasonable compensation? Reasonable compensation is interpreted based on the industries. So you would have to show like comparable works and what you bear the burden to prove that comparable works and what they generated and what the reasonable license fee would be. It gets into creative arguments, but the law will imply an agreement based on those settings.
Okay.
So it's important. Okay. It's important now to confirm your meeting, and maybe in a follow-up email. Were you corresponding by email at all, or just by writing?
We did it by phone, but they send a feedback report after every meeting where you give me a grade. So that can be correspondence that proves our meeting. And I did save that.
Okay, save that. And how have you been corresponding?
Well, I usually correspond via email or snail mail when I do correspond.
Well, send regular mail and also send an email and confirm that your work is, if it's ever used in any way, you expect reasonable compensation.
Okay.
That's all. Real simple. It could be in a thank you letter. Like, thank you for sending it back. Okay. If the work is used in any way, there is an understanding that you will be compensated.
Okay. All right. That makes sense.
It's about the document trail. If there's ever a dispute, cases are won on the documents. What you can prove, documentary evidence.
All right, great. So I do have proof that the meeting took place via an email, a follow-up email, and that there was a pitch regarding that particular script. And that script is copyrighted as well. I do have the certificate, and I have it on digits as well. So if they, steal scenes and structure, I can actually prove it with my script, and I have the copyright. So that's technically, for the most part, if they like steal my script verbatim, if they steal all the scenes and the beginning and the opening and the middle and stuff like
Oh,
that.
absolutely. There's different presumptions if there's verbatim copying. Verbatim,
Okay.
yeah, verbatim copying could be grounds for punitive.
Okay. I think the only thing they can do is probably just steal my concept and write their own version of the story and not, use my scenes.
Well, we can, that's why it's important to document it and say if your work was used in any way, whether it's being used to create a derivative work. A derivative work is one that is derived from the original. Okay. And only the copyright owner can make derivative works. That's one of their exclusive rights to copyright. But what is a derivative work versus a transformative work, which is not protected by copyright? Because again, let's remember that the Copyright Act was not created to create a monopoly. It was not created to create a restriction on creativity. That's not the purpose. The purpose was, in fact, to inspire new creations. Fair use doctrine was developed, and the transformative work doctrine. Okay? And we can get into that more as to what qualifies for a transformative work and what are the elements of fair use doctrine. It's a balancing act. They take a number of factors and they balance it. Some courts may come to different decisions. It's based on the jurisdiction and their precedent. Kind of have to get a feel for the community there. That's how they set community standards.
Okay. All right. So yeah, I'm particularly concerned about that particular script because that's one of my favorite ones. It's a bigger script. I definitely been trying to get it to Spielberg. It is posted on Stage 32 website and Coverfly website, and it has been submitted to different contests. So, I have evidence of all of that. So maybe I can create a paper trail if something happens.
Absolutely.
Okay.
It's all about the paper trail. Document, document, document.
All right. Yes. So that's pretty much that. I received the copyright letter for my script, The Myrtles, and that's pretty much it.
Very, very cool. All right. Well, keep checking in. I would recommend that you do confirm your submission. I mean, even though they returned it, they could have opened it. They could have read it. You don't know exactly what happened with your work when it left your hand. The only way you can truly protect your work is by locking it up in your desk drawer and never showing it to anyone. But now you have a duty to police.
Mm-hmm.
You can merge it into a polite thank you letter. Okay. I would suggest sending things by certified mail with tracking. Okay. No more snail mail. That doesn't really prove anything. You can't use that as a offer of proof in the court. It's not certified. There's no foundation. What I will say this is what you essentially have, depending on what's in that letter, if you opened it, is now what we call a poor man's copyright. You know what a poor man's copyright is?
Yeah, when you mail your script to yourself.
Yeah, I mean, if you want to just keep that letter as evidence and don't open it, because that's the evidence. When you can bring it in court and then open it and see what's inside. But the only way it's preserved is if you don't open it. But I wouldn't recommend doing that. That's mythical, Tony. You have access to the U.S. Library of Congress. All right. A poor man's copyright doesn't hold up in court. Never seen it. Never will happen. There's too many foundational objections. There's no such thing as a poor man's copyright. The only thing that counts is your copyright registration with the Library of Congress. That's the federal agency. They make the rules. The court respects their registration and honors the date and holds the public accountable based on that date. Make sense? You're on mute.
You're automatically protected by copyright once you start writing anyway, right? You just have to prove that you wrote it on this date.
Yeah. How are you going to prove it? You know, yes, there are common law copyrights. Copyright adheres at the moment of creation. Yes, fundamentally, theoretically, by law, yes, you are right. But you get added protections, which essentially is our lawmakers saying you get added protections by filing for federal copyright registration, which is our legislature, our lawmakers basically saying in one way or another that proving common law rights is going to be very difficult. The courts are not going to really honor it. And if you're going to come into the court with the common law rights argument, they are going to look at your case negatively. Okay? You gotta treat your work professionally. You gotta register your work with the Library of Congress. Okay, it's a cost of doing business for you. You have to put that into your business plan, your projections. As a writer, as a creator, you should be filing copyright registrations regularly. I don't know what your output is, but I know writers who do multiple copyrights a week. Yes, it adds up, but you got to put it on your bottom line as part of your business. You need those rights. You have no business. You have no way to monetize your work if you're relying on common law copyrights. People are going to steal it. They're going to steal it. First in time prevails. They'll steal it and they'll register the copyright in their own name. And then boom, you're at a disadvantage. You're starting from behind because now you have to challenge that copyright. You're the challenger rather than one who's holding the rights. Do you get it? I see it a little bit more animated. I see it a little bit more in color. I can see how the things go down. All right. Because I know the arguments that can be made and I know how procedurally things will work and how the courts will view the case. Common law rights are not as strong. They're weak rights. And if you're relying on weak rights, you're in a weak position. And if there's ever a dispute and one party has a piece of work filed with the federal government and one other party doesn't, and they're saying they're relying on common law rights, they're going to balance the strengths of the rights. And you're going to lose. They can in essence legally steal your work if they beat you to registering it. Do you get it?
Yeah.
You have to be proactive with your copyright registrations. For each PDF that you upload, I believe it's like an $85 fee. You have to put that into your bottom line. How as a writer, how much your production, what's your output? Are you doing 10 scripts a year? What's your output? So you can project your bottom line in terms of copyright registrations. That should be a category of expense in of itself. You can't disregard copyright.
Yep, got it. Yep. So that's that. And I think for the next month or two, I'll be kind of hanging back a little bit, getting notes on my superhero parody and preparing for my biopic script and still trying to get representation. So that's that.
Well, like I know we discussed it before, management and entertainment council kind of merge. All right. A lot of managers are lawyers, lawyers are managers. So if you ever want to discuss how I can work with you in that regard, we can discuss as well.
Oh, okay. Yeah, definitely. How much would what would it cost? What is your fee to do a consultation?
I have a website on it, so I can send you the link.
Okay.
Again, this is kind of just secondary, something I do as a hobby because I honestly enjoy helping people improve their careers, their hopes, their dreams, and ambitions in life. So I like to stay involved. Of course, lawyering takes up all my time. But like I said, my background as a lawyer is very valuable in regards to managing a talent's career. What exactly is management is quite broad. I mean, you can have financial managers, you can have personal managers, you can have talent managers. It takes on many different hats. Managers are not regulated by the state, whereas agents are. All right. So a lot of people don't know the distinction. Agents are licensed by the state, and they are the professional that can, and here is the legal term, procure you employment. And that's an interpreted term of art. Procure you employment. So anything within the employment process must be done by a licensed agent. Um, Sometimes there's a gray line in terms of reviewing contracts. Like sometimes is that in part of the employment process. It's a difficult area. Okay. Um, but managers are not licensed. They're kind of like a freelancer, and it's really what you need. Any manager that helps you succeed is worth whatever charge they may have. Okay, it depends on what you need. But yeah, I do offer a lot of systems, that I implement on my own self. We find them to be productive and help you achieve success. So if that's something you want to talk about, I can send you the link as well.
Okay. Yeah, definitely. Definitely looking for management or somebody that can
Yeah, I'm
submit
just
my work to studios
yeah.
or
I have
something.
I have I think I told you about it before, but I don't really market so much management for my entertainment uh talent, only because I'm very selective with who I work with. I like to have an established relationship, and um, I'm just very selective with who I deal with in terms of entertainment management. My client roster I keep very limited, and yeah, we can talk more if you'd like.
Okay, yeah, let's do it. Let's see. Let me send you a text.
Yeah, I can send you the website, but it's just a basic landing page website, and usually, I mean, the rates usually are comparable to my general counsel services because they're very similar. My general counsel and talent management is it's similar, very overlapping, same issues. And yeah, here I can send you the info. I can message you directly in Dialpad where I just messaged you. But yeah, we can talk more about that. We do have to take care of some other business matters. It was nice to just connect. I know last week you signed on. I was about to admit you, but you disappeared. Yeah, so sometimes we get caught up in discussions before admitting participants, and I constantly have to check to see if anyone's logged on. So sometimes we get, just be patient. If you ever log on and it takes, you'll get in probably within 5 to 10 minutes. But if it's longer than that, then that means, some emergency work has been brought up and has taken us away.
All right. Yeah. So thanks for your time, Justin. I'm going to look at this website and then I'll text you or contact you if I need to set up an appointment.
Absolutely. All right. Thank you, Anthony. You have a good day.
Have a good week. Bye.
Bye-bye. All right, guys. We can stop streaming now.